Good morning, afternoon, and evening to the viewers. In this video, I will be talking about AI, specifically generative AI models like ChatGPT or Google's Gemini. Specifically, I will be looking into how these AI companies might have been violating copyright laws, as well as how does fair use or fair dealing laws comes into play when it comes to these generative AIs. And also, I will be looking into if AI generated content can be considered to be transformative enough to stand on its own legs as an independent creation, or are these generative AIs and its creations just simply regurgitating aspects of its training data? So firstly, I think a good place to start this video will be to briefly talk about what exactly are AIs. The simplest way to explain this is to say that AIs are essentially computer systems that are smart and capable enough to perform tasks that normally require human intelligence. But not just that, a lot of the times, these AI systems are also built with the purpose of them getting better and better with as little human involvement as possible. How is all this possible? Well, it is possible in the first place because these machines and these AI systems had to have went through a learning process of some sort via machine learning models that are built from algorithms that are trained using data sets. For example, in the case of generative AIs like ChatGPT, these AI models might have been trained using works from different artists which would have been protected by copyright. And this is where copyright laws might come into play in this regard. At its most basic level, copyright law serves as a tool to empower creators and their works. It allows temporary monopoly on a creation, which can be a source of financial gain, while also shielding the creators from any unauthorized usage of their work. I've touched on how AI models might be trained on large data sets before. So as a result, a lot of authors and companies have filed lawsuits against AI companies for using their works. These authors or companies will claim that they did not consent their works to be reproduced for AI training. But do they have a point? Well, this can depend on a few factors. Like, for example, it can really depend on where this question is asked. So for example, in the UK, in section 29 of the Copyright Design and Patents Act 1988, it states that text and data mining is strictly limited to non-commercial research. Thereby, it sort of limits the companies from using it to research to train their generative AI. Whereas in other places like the EU or the Singapore, these places have wider provisions to potentially allow for generative AI models to be trained. So or looking on the other side, the AI companies will claim that their models might be trained with data that is publicly available on the internet. So this is commonly called data scraping and is actually not illegal, especially in certain jurisdictions and certain contexts. So on top of that, the practice of data mining itself could also be legal under certain jurisdictions like the EU, for example. So the question is, which side is right? The authors, the companies, or the AI models companies? So this is a question that will remain unresolved until we get some conclusive judgments from the lawsuits from these authors against the AI companies, I think. This brings us into the concept of fair use in the United States, or fair dealing as it's called in the UK. So what are they? Simply put, it is a means in which certain users of an artistic work do not require permission from the copyright owner so long as the use is considered to be fair. Specifically, in Section 29 and 30 of the Copyrights, Designs and Patents Act in the UK states that fair dealing is allowed for the purposes of non-commercial research or study, criticism or review, or for the reporting of current events. So in terms of generative AI, this means that the courts will look at different factors when considering fair use or fair dealing, such as the purpose of the AI generated content. For example, was the generated content used for a commercial exploitation purpose, or is it merely for research or educational purposes instead? Also, it will consider whether the AI generated work is transformative enough to constitute fair use. And a good example, good case that showcase some of these factors being considered is the American case of Authors Guild against Google. The judgment of the case shows that some of these factors, the courts did consider some of these factors when coming into its judgment, and you can say that the AI laws might follow similar, AI cases may follow similar precedents as well. Could an AI generated work be transformative enough to stand on its own? And crucially, will it be allowed to stand on its own from a legal standpoint? Well, to be honest, that really depends on just how much human involvement there is in the work's creation. As most jurisdictions, including the UK, require that the work must have some form of human involvement to offer his creative inputs in order for the work to be granted copyright to the AI prompter. We know that AI models nowadays can create wholly original works that bear little to no resemblance to its training data, and sometimes with little to even no human involvement. For example, an AI model was able to create the next Rembrandt painting by simply analyzing thousands of other Rembrandt works. Therefore, the question remains as to who is the author of such works. Could we really be giving the legal protections to non-human entities? And how do we strike a balance between protecting and encouraging human creativity and at the same time also encouraging AI innovation to get better? So these are the questions that lawmakers all around the world must grapple with, as there is no black and white easy answers to this. This is, as we step forward into the AI era, this is a debate that will continue to rage on.